get rational basis, and we're going to affirm the government's decision. How does that work in practice? Kwong v. Bloomberg, the Second Circuit case, is one of my favorite examples of this. In New York City, it costs you over $300 to get the license to have a handgun in your home, and that has to be renewed every 3 years. So it's about $100 a year or more on the license to have a gun at home. Okay? And Kwong challenged this and said, look, it burdens my Second Amendment rights. I don't want to spend $300 to exercise my fundamental rights. And the court said, no, the tax is not a marginal, incremental, or even appreciable restraint on Second Amendment rights, especially because the plaintiff didn't argue that it was prohibitively expensive. So if it's not going to put you in bankruptcy court, then who cares? And it's only $300, suck it up. And that, I've been to New York City many times. I enjoy it. I would submit to you that if you take $300 or even $100 and drop it on the sidewalk in Foley Plaza outside the federal courthouse, someone's going to pick it up. Okay? It's important. Even a federal judge might do that. I would also ask you this by show of hands. I mean, let's be realistic here. What if the Second Circuit was presented with a challenge to a $100 tax on an abortion? Does anybody think that they would say, oh, who cares? It's not even a marginal or incremental restriction on the right. $100 abortion tax goes to fund the regulation of healthcare facilities. It's a good cause. No hands. How about a $100 fee to obtain voter ID in New York City? Would that fly? Okay. So this shows you the problem with interest balancing and substantial burdens. The Ninth Circuit joined this in a case that I had on cert, which I didn't get, but that was pre-Kavanaugh. And this was a crazy situation. What happens if the facts are so bad for the government that the government can't hope to win under any kind of interest balancing, as long as the government has the burden of proof? My clients tried to open a gun store in Alameda County. They wanted to have a full-service gun store with training and licenses and all kinds of stuff, a facility that they didn't think existed that people in the county could use. That is a zoning issue, which all businesses have in California. And the upshot of it was that after a lot of review and hearings and evidence and so on, the planning commission said, you're going to get your conditional use permit. We're going to give you a variance that you need. This is a necessary use of property. It's useful to the community. It does not conflict with any other neighboring land uses. It's safe. It's wonderful. Here's your licenses. Well, the neighbors who didn't like the gun store went to the County Board of Supervisors, and the County Board of Supervisors summarily reversed that decision. The gun store owners, putative owners, went to court and said, this is violating our Second Amendment rights and the rights of our customers to access firearms. And right now this looks like any other kind of constitutional zoning case, right? When bookstores and movie theaters and other people, abortion clinics, have an argument that their business provides constitutionally protected goods and services, then planning land use decisions have a constitutional dimension, and you can go to court for that. What did the Ninth Circuit say? Well, the Ninth Circuit had a string of decisions that said, we're going to look to see how serious the Second Amendment violation is. If it's not substantial, we'll reduce the standard of review to intermediate. Okay, under intermediate scrutiny, the government still has to show a reason for this restriction. And here, the government's planning commission said there's no harm from this use. So en banc, the Ninth Circuit said, well, you weren't meaningfully constrained. It doesn't actually or really burden Second Amendment rights because there are other places in the county where you can go buy a gun. Try that with a bookstore. There are other bookstores, as Amazon.com. We can ban your store because people can go get a book somewhere else. And it's not a matter of heightened scrutiny, even though you have a First Amendment right to buy and sell books. But what if they said, okay, it's strict scrutiny? What if they said this is super duper, ultra strict, GLOT scrutiny, right? You have to, absolutely have narrow tailoring. Well, that's a case I handled and lost 8-7 in the Fifth Circuit, up for cert also, called Mance versus Whitaker now. This is a case that concerned the interstate handgun sales ban. A lot of folks in this room might know that you can buy a rifle or shotgun anywhere you want in America, so long as the dealer performs a background check and so long as the transaction complies with the laws of your home state and that of the state where the dealer is located, but not for handguns. Handguns, forget it, it's a total ban. You can only take possession of a handgun from a licensed dealer in your own state. And what is the reason for that? Well, we don't want people running around crossing state lines to avoid their local handgun laws. Well, that's a nice reason, except that some states want interstate sales. Or some states have so much gun control that there's nothing to circumvent. The example I give is Washington, D.C., which is where my clients are from. Washington, D.C. has no gun stores, okay? You cannot buy a handgun from a store. Nobody has the inventory. There's no retail outlet for guns. How do people get handguns in Washington? There's one guy who has an FFL, a federal license, who sits in the basement of the police station, and for $125 per transfer, he will open up a FedEx package that was sent to him from somewhere else and process the paperwork for you. So if you want a handgun in D.C., you go to Virginia or Maryland or somewhere else, you pick out the handgun, I want that one, you take all the information down to the D.C. police station, they do what they need to do, they issue you a certificate to possess the gun, and then you present your certificate to the $125 extra nice man in the basement, and you can take possession of your handgun. Now notice what the D.C. police are doing here. They do this, by the way, for all guns. It's not handgun specific. They do it for rifles and shotguns also. They register the gun to you before you touch it, okay? So there's no question once you've got that certificate that you're allowed to have it. So why can't I go to another state, if I live in D.C., where there are no gun stores, and so long as the police chief has given me a certificate, why can't I go back to the store and pick it up? Why do I have to do this middleman for $125? He's not doing anything. The police have already approved it. There's no state anti-circumvention interest. So my clients flew from Washington, D.C. to Texas. Texas allows interstate sales. Washington, D.C. does as well. And in fact, they license them this way. And they said, look, we want to pick up the gun in Texas. We don't have to pay $125 and go through this extra process. We won in the district court in Fort Worth. The government appealed. After a couple of years, the panel reversed and said, strict scrutiny. Well, we have to apply strict scrutiny because it's the right to buy a handgun for your home, blah, blah, blah. But the law is constitutional because FFLs, federally licensed firearms dealers, are essentially too stupid to follow handgun laws of other states and even to understand that this certificate from the D.C. police chief allows you to have a handgun, even though the FFLs are allowed to follow rifle laws and shotguns from other states. And in fact, the FFL could take the very same D.C. Police Department certificate for a rifle and let the people have it. 8-7, there were 3 dissents by Judges Willett, Ho, and Elrod. All 7 dissenters joined all 3 dissents. That's up for cert. We're waiting for the petitioners, for the SG's brief in opposition. I have another case challenging. I want to open up Q&A, so I'll stop at this point. There's another petition that's live right now, which I have out of California, challenging that state's so-called Unsafe Handgun Act, where California says you can only buy a handgun if it's on our special list of not unsafe handguns, because every handgun is unsafe unless we've said otherwise. And now, to even get on that list, you need to be compliant with so-called micro-stamping technology, which does not exist. So they've required a non-existent technology to approve handgun sales. They don't exist. So there have been no new semi-automatic handguns allowed for sale in California for the last 5 years. And this is causing a problem because manufacturers are not going to make obsolete models forever. And there are issues with that. We lost on interest balancing again, so that's the petition. Again, I don't know whether these other petitions will be granted. I would be shocked if they were not at least held for the decision in the New York case. What's the New York case that was granted last week? Second Circuit case. New York has this wonderful law that says if we let you have a handgun, you can only take it to the range in New York City. There are 7 gun ranges in the city of New York. What if you want to take it to your range on Long Island or New Jersey? Can't do it, even if you live closer. So let's say you live right across the street from a range and it's in another jurisdiction, can't do it. You can only transport to a range in New York City, even if the handgun or the gun is unloaded, locked in a separate container from the ammunition in the trunk of a car. There's simply no way to move a gun anywhere other than to one of the specified ranges. What if you have a second home? What if you have a home upstate, and you want, look, I want to spend my summer in, in the Catskills. Nope, the gun stays in New York City. Even if the handgun stays in a vacant home, it could be stolen. Maybe not the safest thing to do. So, the rationale that New York has is we don't want guns on the streets because they might spontaneously explode and cause problems. But look, we're talking about guns that are not being carried for defense. We're talking about guns that are locked and unloaded. And if you're worried about guns traveling up and down the streets of New York, you're actually forcing more of that activity because it might well be that a person lives closer to an out-of-New York gun range than to one that's in the city. Who knows? The Second Circuit said it's intermediate scrutiny. What are you complaining about? You have no harm because you can just buy another gun for your second home, and you can rent a gun at the other range. And, this is the kind of reasoning that we got. But the Supreme Court decided to review that. Just a small caveat with that, there are also Commerce Clause and right to travel arguments in that petition. So one could imagine they might duck the Second Amendment question and rule on these other grounds. I kind of doubt that, but one never knows. But we'll find out soon enough. In any event, I've talked long enough. I could talk longer, but I do want a lot of time for Q&A, so I'll shut up and let you guys ask questions. Thanks.
All right, I guess just go ahead. Just call
I'll call him. Sure.
A lot of different states have felony expungement laws. Once it gets expunged, for example, I had a case where a guy had hit his kid in the head with a crane. He got mad, he got upset, hit his kid in the head. The kid was a baby, crushed his skull, he got arrested. He did a couple of years in jail. Anyway, 5 years later, I represented him to get his one felony expunged. This kid was okay, his wife wanted him not to have the felony. Anyway, he got his felony expunged. Does that still have any bearing on whether or not he could own a gun? Is he still considered a felon even after the felony is expunged?
Depends what court you're in. It depends on the state. First of all, under the federal scheme, there is an automatic restoration if you have an expungement or a restoration of civil rights and so on. I'm sure if you're an attorney, you're familiar with that, but it doesn't always count. It depends on state law. If the state law says, we'll expunge your felony, but you're still prohibited, or if there are some kind of restrictions that linger, like, well, you can have a gun, you just can't get a concealed carry permit, then it's not considered a full expungement for purposes of the statute. But what happens for constitutional purposes? I had a case called Hamilton, and this is a terrible case. Who's Mr. Hamilton? He was a gentleman who committed credit card fraud, nonviolent crime. He allowed someone to pay him back for a personal debt by going to a Best Buy and using somebody else's credit card. He got all of his rights restored in the state where this happened, which was Virginia. And he did everything such that it also made a full federal restoration. He got his rights restored in every single way, so he could have a gun in Virginia and also anywhere under federal law. The federal government no longer considered him to be prohibited. Okay? He became a firearms instructor and a security guard, and now he's a Department of Homeland Security Federal Protective Officer. Okay? What's his problem? He doesn't live in Virginia, he lives in Maryland. And Maryland has a felon dispossession law, and Maryland is very anti-gun, and Maryland did not care about this restoration. So they would not let him have a gun. And we sued, and we said, this is crazy. This is a federal police officer with a nonviolent conviction for which he's been fully restored. Lost in the Fourth Circuit. He said, once a felon, always a felon, we don't care. And by the way, we know that we've said that we recognize felon as applied challenges before, but now we've changed our mind, and we're going to put the following limitation. This is the crazy, I went to this argument. I said, look, you have 4 opinions in the circuit that say you recognize this process. They said, well, we're going to reconsider. So the only felons in the Fourth Circuit who can get, who can make a challenge to the felon dispossession law are felons who have been pardoned, which means they're not felons anymore, or felons who can show that there was something unconstitutional about their conviction. like they're convicted of something that's no longer a crime. And
Do they apply that to juveniles as well, if you have a sealed juvenile record of felony?
the Fourth Circuit hasn't explained that. I believe that there's a bad case somewhere else, in the First Circuit, I think. So it's, yeah, so that's very useful. So Mr. Hamilton doesn't have a gun in his house, even though he goes to work and has guns there, walking around Washington, D.C. with guns, serving as a security guard. By the way, I hope he's getting paid. But that shows you the level of hostility and dishonesty, and I'm sorry with I shouldn't say dishonesty, but it's tough when you have a line of precedent and you go to court with it, and they say, well, we didn't really mean that because now it means we're going to have to actually let you win. So that's where we are. Cert was denied on that.
So I'm just curious, if the lower courts haven't been faithful to the majority opinion in Heller, why haven't appeals come before the court? Why hasn't the Supreme Court taken cases? I mean, they've had this 5-member majority for a long time.
Maybe they haven't. That's the thing. Everybody, there have been justices popping off once in a while. Usually Thomas, Scalia, Gorsuch, sometimes Alito, saying we need to look at this. It takes 4 to grant cert, but maybe you won't get that 4th vote for cert unless they know what the 5th one looks like. And there was a lot of silence from both the Chief Justice and from Justice Kennedy. And so there's this parlor game about which of these two are the ones that are kind of shaky, or did somebody change their mind? And that's obviously over now because cert's been granted. But look, they don't. It's been a problem. They don't have to grant cert just because they should. There are a lot of really great cert petitions that get denied every year. You can make a Supreme Court docket of 200 cases with 200 very solid, deserving cert petitions, but they only take about 60 or 70 now, which is less than what they used to be. They used to be like 150, but they've really stopped working there. I mean, they generate. Well, no, I should say, but it's true. This is a court that's not really doing its job to settle disputes in the lower courts. You had a court that used to take, well over 100 cases a year. I've seen a study somewhere that said that they write the same number of words, okay? So they generate the same amount of paper, but in fewer cases. And I think that's bad too. It's bad, I think, to have short cases that are to the point and not all this ambiguousness on the one hand, and Justice so-and-so concurs in Part 2A and 3B, and you need a flow chart to figure out what it means. That's not helpful. That's not helpful to lawyers and judges either. So I wish the court would go back to a practice of more opinions, maybe more summary reversals. No, this is not what we said in Heller, try again. That's useful too. But the lower courts have come to know that it's optional. And that's why we've had some of these decisions. And some courts are very good. Other courts, less so. The Seventh Circuit's usually strong, not always. The Ninth Circuit, the Second Circuit, the Fourth Circuit, I don't think they'll ever see a Second Amendment violation. Ever. Up there.
So I'm just curious. I've lived in Japan and have several different professors in my undergrad who are Japanese, and they are a very anti-gun kind of mindset country. And just obviously we have the Second Amendment, and without further amendments to change that, it makes sense to uphold our constitutional rights. I'm just curious where you would stand, or where a lot of the feeling is among people who are pursuing protecting the Second Amendment. Other countries seem to be quite happy without having guns, and what's the value of us not in the future getting rid of the Second Amendment through another amendment that deals with it, per se?
Well, look, we've gotten rid of things before. We had prohibition, then we didn't have it. We got rid of things. Look, I usually don't answer. When I go to court, that's more of a philosophical debate. I think that the Second Amendment's a good idea. I think it's important that people retain the right to defend themselves, both because the police, number one, owe you no duty, and they're not always going to get there. And also, I do think that it's there for the other reason, which is that people need to retain some amount of power so that they have a means of resisting tyranny, as we did, and as many people have needed to do. And if you look at the news today, I mean, is the Second Amendment, would that be a good idea today in Venezuela, where people were disarmed a few years ago? I submit that it would be. You have many governments that commit atrocities against their population, and I think that people need to have some check on that. Is it perfect? No. I mean, obviously there are problems, and we should try to do what we can to reduce the incidence of gun violence and we can maybe do better in some ways. But look, Japan is Japan. They have a different culture and a different balance, and we're not Japan. Japan, it's only been a few years that Japan has had jury trials. This is a new thing for them. I remember when I litigated McDonald, we talked about that. That was just starting, this jury concept. Japan also has other problems that we don't have. Last time I looked at it, I believe that Japan's suicide rate is higher than our combined suicide and violent crime rate. So very few guns are used, but people hurt themselves in other ways for other reasons that are cultural and historical and unique to that situation. So every country is different. I don't believe that every country needs to have the exact same set of laws. Not every state needs to have the same kind of laws, right? We live in we have 50 laboratories of democracy, and Utah is not going to have the same laws as New York. But there are national standards, right? The Constitution sets a floor, and within that range, you can have different laws. You just can't violate people's federally guaranteed constitutional rights. We settled that with the 14th Amendment.
You brought up the idea that all constitutional rights should be treated sort of equally, protected robustly, and you brought up like a tax on abortion or a tax on voting as examples that wouldn't be acceptable. I'm wondering what your response to the counter-argument is that we have different zones of protection for different constitutional rights because they exist in the real world and have different consequences. So for example, it makes sense to give robust speech and privacy protections, but maybe to have narrower Second Amendment protections because of the consequences that we've seen flowing from legally obtained firearms.
The Supreme Court has repeatedly rejected the concept that there's a hierarchy of rights. Okay, they simply aren't going to go down that path and say, well, the First Amendment's really important, but only the speech clause or the free exercise clause, and the right to criminal defense is, that's less important. We shouldn't have to pay for that, or make sure people get, representation, and due process is somewhere in the middle, and who really needs cruel and unusual. The court doesn't do that. Okay, these are rights. Now you can have a disagreement about the scope of the right, okay, which is a textual and historical analysis. I'll never forget. I debated shortly after Heller. I was in a venue somewhere with Walter Dellinger, the former Solicitor General, who argued against me in Heller in the Supreme Court, and somebody asked this question, and he said that he had clerked for Justice Black, and Justice Hugo Black is known as a First Amendment absolutist. He was very fond of the First Amendment, but Mr. Dellinger said that Justice Black probably would not have found that flag burning is protected by the First Amendment, because to him that was conduct and not speech. And so you can have disagreements. You can be very vociferously for a right, but think it has a different contour or it extends differently. But what you can't say is, I know the framers gave us this set of rights, or that there are these set of rights, but I'm the judge, and to me this right is less important or less of a good idea, so I'm not going to treat it the same way. At that point, you really don't have a constitution anymore. You have the personal predilections of random people who happen to be on the bench in your case, and that's not the Constitution. So if you think that a regulation makes sense, if you think that because the danger of this activity is such that the law is reasonably tailored to it, that's one thing. But you can't say, well, it's the Second Amendment, that's kind of the third tier thing, and my view of strict scrutiny in the Second Amendment is not going to be all that strict compared to what I'd apply in the First Amendment. And no, we just can't have that. I mean, I'm sure everybody here, if I asked everyone in this room to rank their favorite constitutional rights, people would have different lists. Some people would say the Second Amendment's at the top, some people might say it's at the bottom, or somewhere in between, and maybe somebody really, really cares about, I don't know, some right that is less popular, like quartering. I like to travel. I like the right to international travel because I like to travel. To me, the Dulles case is important, but you can't do that. I'll take it.
We'll do one last one.
I'm sorry. Okay, sure.
So clearly your specialization is unique. How did you become a second rights amendment lawyer? Could you tell us why
Okay.
is your path?
I'm not actually. I'm not limited by subject matter. I don't consider myself a Second Amendment lawyer. I have a lot of Second Amendment cases, but it's, if you want to be litigating public interest, then you make a career that is, and this is really for anything you want to do, if you want to go into a certain area of law, make sure that the jobs you take teach you that area of law. Okay, so if you're going to get out of this law school and become a tax lawyer your first 5 or 10 years, it's going to be hard for you to transition into, say, complex federal litigation or immigration or criminal defense. At some point you are what you do. I've had a series of jobs early on in my career that exposed me to constitutional law and to complex federal litigation, so I was able to turn that into a practice where those are the types of cases I handle. And then one day I got a phone call from Bob Levy at Cato, who said, hey, we're making this case, we're going to challenge the DC gun laws, we think it's a good idea. Do you want to be on it? We need somebody to be lead counsel. And I said, sure, it sounds like a good idea. And having won Heller, that opened up other opportunities, and it would have been foolish for me not to take advantage of those, and so I did. At the same time, it's a challenge because if you become well known all of a sudden for one thing, as happened to me, then people say, oh, that's the gun guy. Well, that's great. I suppose you could say that, but that's very limiting as a business. And so, I always have to remind people, look, I do this because I've done it, and people come to me with these cases, and I choose to do them. But I do other things as well. I mean, I'm waiting right now I argued a First Amendment TRO earlier this week in Washington, D.C., dealing with the shutdown. It's very interesting stuff. And I'm expecting a decision any moment. I'll turn my phone on. I might have an order from the court. So no, I do other things as well. But if you want to do this kind of stuff or any kind of stuff, be attuned to the idea that, don't just take any job. I mean, at some point, maybe you have to if you need money and this is what you're offered, but try to, move your career in the direction of the things that are interesting to you that you want to pursue.
Thanks so much.
Thanks so much. Thanks. Thanks. Sure. Sure. All right. This is good. All right, good. Thanks. How about this one? That's a good crowd too.
Sorry. I meant to ask.